Okay, so in previous classes, we discussed the formal requirements for patentability, specifically the requirements relating to the patent claims, how they're read, and how they're read in light of the patent specification, as well as the requirements imposed on the specification itself in order to substantiate the claims. For the next several classes, what we're talking about are the substantive requirements for patentability. In other words, what kinds of things can be patented in the first place and why. For substantive requirements, first, that the material claimed or that the patent claims reflect patentable subject matter. In other words, are they the kind of thing that can be patented in the first place? And then in addition, does the invention or discovery claimed have both utility, novelty, and non-obvious? In other words, can you use it for something? Is it new or not previously invented? And is it the kind of invention that a Fozita couldn't identify or come up with themselves simply by looking at the current state of the field? In other words, have you done something actually new or only trivially new and therefore obvious to a Fozita? So in today's class, we're talking about the patentable subject matter requirement, the kind of most fundamental ground level bar or kind of requirement for patentability. In other words, in order to claim a patent on an invention or discovery, it has to be the kind of invention or discovery that patent law was intended to protect. And the fundamental basis or the kind of the fountain from which the section 10, or rather the patentable subject matter requirement springs is section 101 of the Patent Act. Otherwise, we refer to the 101 requirement for patentability, namely that it's the kind of things that patents can protect. And it's a pretty broadly worded and general statement made by Congress about what it is that patents can statutorily protect, maybe constitutionally as well, but at the very least as a matter of statute. A patent can issue whenever somebody invents or discovers a new and useful process, machine, manufacture, or composition of matter. So what does that mean in terms of what is patentable? Well, we've got a list of 4 different categories of inventive activity that can be the subject matter of a patent, namely a process, a machine, a manufacture, or a composition of matter. And surprise, surprise, all 4 of these have been defined very, very broadly. So the scope of patentable subject matter is quite broad, but there are certain limitations. And these limitations have been identified primarily as kind of discrete categories, more or less, of inventions and discoveries that are excluded from the scope of patent protection. The 4 kind of classic limitations on patentability, on patentable subject matter, are mathematical formulae, right? So a pure mathematical formula can't be the subject of patent protection. Laws of nature, in other words, a kind of a mathematical expression of, or other form of expression of simply the way the world happens to work. Things found in nature, so some things that simply exist in nature by themselves and aren't modified by human activity, and abstract ideas, whatever an abstract idea happens to mean. It's possible that other limitations on the scope of patentable subject matter might emerge. In fact, many people believe, and the Supreme Court has indicated some sympathy to the idea that business methods or ways of doing business might also be the kinds of things that would be excluded from subject matter, patentable subject matter. At the very least, the Supreme Court seems to have narrowed the scope of the kinds of things that could be patentable as business methods, although it has not yet, at least, explicitly excluded business methods from the scope of patent protection. Okay, well, so how can we sort of identify the development of this 101 requirement? Well, the modern concept of patentable subject matter really kind of stems from Diamond v. Chakrabarty. Now, what happened there? Essentially, the inventor applied for and received a patent on an oil-eating bacterium that had been created in a laboratory, right? So early days of genetic engineering, they created a new and useful bacteria that didn't previously exist in nature, that had useful properties of eating oil, good for oil cleanup, and other uses. And the question was, can you patent a living thing? And the court said, sure, that's fine. Living things are fine. They're not excluded from patent protection. After all, patent protection goes to anything that is a process, machine, manufacture, or composition of matter. That can include a bacterium, so long as the bacterium is created by humankind, right? So the bacterium didn't previously exist in nature. It was created in a lab by a person. That makes it patentable subject matter. And it doesn't matter that it happens to be a living thing, namely a bacterium. Okay, fair enough. Then the question becomes, how broadly are we going to construe that? And how are we going to think about the exclusions from patentable subject matter in light of applications in particular circumstances? So in the case Simon v. Diehr, a year later, the question became, can a mathematical formula as applied to a method of curing rubber be the subject of patent protection? And there the court said, absolutely, sure, no problem at all. You can't patent the mathematical formula itself, right? That's a mathematical formula that also effectively describes a law of nature, right? It describes how something actually works in the world, but you can patent or obtain a patent on a particular way of applying that mathematical formula in context. So using the mathematical formula to increase the efficiency of a method of curing rubber is a patentable application, because it's not patenting the formula itself, it's patenting a way of using the formula in order to achieve a result. Okay, subsequently, the question became, how broadly can that apply? So if you've got a sort of abstract concept, if you simply apply it to a real world scenario, does that make it patentable? And the Supreme Court says, no, not so fast. Wait up here for a second. So in Bilski v. Kappos, the patent claim was over a method of hedging risk, right? So hedging risk is something that people have been doing in financial markets for a long time. And the patent claimant simply said, look, we've come up with a way of doing hedging risk in the market that we think satisfies the other substantive requirements of patentability. Can we claim a patent on the formula, on this method? And the court said no. Right? This is too abstract. This is a business method that's been around for a long time, and you can't patent its simple application to the actual market. That's not sufficient. Okay. Moving forward, in Mayo v. Prometheus, the patent concerned a method of determining the dosage of a drug for treating autoimmune diseases that was patented and owned by Prometheus Labs, which licensed initially this patented method to Mayo. And Mayo ultimately decided that they didn't want to license it anymore and wanted to come up with their own test using essentially the same method. And what was the method in question? Well, the method was essentially to say, look, apply some of this drug, see how the person's body responds to it. In other words, how much do they absorb, and then adjust the dosage based on the rate of absorption of the particular drug in order to ensure that they get a therapeutic dose and not a toxic dose of the drug in question. And the Supreme Court says, look, you can't claim a patent over a test or a method of administering a drug that consists of nothing but guess and check, essentially, as to how much to administer. Right here, you're just saying, give them a little bit, see how they do, and give them more, give them a little bit less, depending on how they respond to the drug treatment in question. Yes, you're kind of stating implicitly a formula about how different bodies absorb the drug differently, but at the end of the day, you're really just saying some people absorb it more, some people absorb it less, and you need to guess and check to see how their absorption goes before you decide what the ultimate dose you're going to give them is going to be. That's really a way of trying to patent a law of nature, namely that absorption differs from person to person, and you have to observe what actually happens in nature in order to determine what the dosage should be. That's excluded from the scope of patentable subject matter. There's got to be something else going on in your invention or discovery in order for it to be the subject of patent protection. Moving on, in Myriad genetics, the question was whether or not Myriad could claim patent protection over a particular set of genes. So essentially what they did was isolate the BRCA1 and 2 genes, which were important for the causation and thus the prediction of breast cancer. So essentially this was a way of testing people to see if they were at risk of developing breast cancer, and they applied for a patent over the isolated genes. And the Supreme Court ultimately kind of, as we might say, split hairs on this one a little bit, saying, well, you can't claim patent protection over the isolated gene itself, because that's just a gene sequence that appears in nature on the DNA sequence of a person who has a proclivity to breast cancer. Now, yes, you've isolated that sequence, but it's still the sequence as it appears on their DNA. However, you can claim patent protection over RNA sequences that you've generated in the lab, essentially by copying the DNA, because those RNA sequences don't exist in nature until you create them by making a copy of the DNA sequences in question. In other words, they kind of go back to the Chakrabarty heuristic or rubric for determining whether or not an invention or discovery is patentable by saying, well, the bacterium is patentable because you created it in the lab. The DNA sequences are not patentable because they exist in people's bodies. The RNA sequences are patentable because you created them in the lab. Now, that makes some kind of formal sense in the logic of the law. A lot of scientists think it doesn't make practical sense in terms of how things actually work in the laboratory, and that the RNA sequence and the DNA sequence are essentially the same thing. So saying you can patent one but not the other is kind of incoherent. Moving on, in Alice Corp, we then return to the kind of Bilski problem, right? And so what happened in Alice was the patent owner had been issued a patent on a method of mitigating settlement risk using a third-party intermediary that was then implemented by a computer, right? So essentially, this is a way of saying you use a third party to mitigate the risk that somebody's not going to pay for whatever it is that they want you to do, right? So if you say, I'm going to give you money if you do X for me, the problem is, what if you give them the money and they don't do X? What do you do about it? Well, third-party settlement risk mitigation means you give it to a third party, and the third party says to the person you want to do something, we'll give you the money as soon as you do the thing. That way, both parties have someone in the middle whose only job is to make sure that they both perform. Okay, well, problem is that's not a new concept, right? That idea of using third parties to mitigate settlement risk has been around for a long time. In fact, we have a word for it. That word is one of those many words is like bank, for example, right? So the patent owner was in effect claiming a bank, the concept of a bank, but not entirely, right? Because they also said, well, but not only do this, but also do it using a computer to make it more efficient and effective. And essentially the Supreme Court said, look, the underlying method is not patentable. And adding to that underlying method, do it on a computer, is not sufficient in the Diamond v. Diehr sense to make it a patentable claim. Doing things on a computer is really kind of de rigueur in today's day and age, and you haven't specified anything special about the way that you're using this concept, this abstract idea of mitigating third-party settlement risk in order to accomplish anything actually that qualifies under the patentable subject matter requirement. On a computer doesn't materially change the abstract nature of the idea that you're claiming.